the North Carolina Professional Association, which under North Carolina law is treated as a C Corp with shareholders, a board of directors, and officers. The district court mistakenly relied on this corporate structure to conclude that Ms. Lemon was not an employee. In its analysis of the first factor of the Clackamas test, whether an organization can hire or fire an individual or set the rules and regulations of the work, the court relied on the fact that Ms. Lemon signed a shareholder agreement, served as a director, and occasionally served as an officer. Yet employees of corporations can be, and often are, shareholders, members of the boards of directors, and officers. The focus should be on who is the most able to control firm's practices and, as a consequence, are least vulnerable to discriminatory treatment prohibited by Title VII. District court's approach fails to meet the remedial purpose. Reliance on business structure is the approach taken by the dissent, Clackamas, and is inapplicable here. Let's look
Mr. Seymour, this is Judge Diaz. Can I interrupt for a second?
Yes,
so in any kind of a structure, business structure, there are going to be a cadre of people who are going to be in charge of the day-to-day operations of that organization, whether it be the officers or some manager that's appointed. But it can't be the case, right, that simply because you have that structure as you had here with this woman partner who you say managed or controlled the operations of the law firm, that the partners in a law firm, simply because they appoint a subset of themselves to manage the operations, thereby suddenly convert themselves into employees, right? So what is it about this case that's different?
Well, in this case, the actual policies and the operation of the day-to-day operations show that in its function and its the setup, it made Ms. Lemon the same as an employee. For example, upon her initial employment in 2001, she signed an employment agreement, and it survived when she became a shareholder. Section 3 of her employment agreement reads in relevant part, "This agreement shall be terminated upon the offer of any stock in the employer by the employee."
Definitely.
So
why would it serve the shareholder agreement? Because the transformation of status.
Well, first of all, the terms, by its terms, the shareholder agreement was designed to include her time as a corporation, because it said that she didn't become a shareholder until 2009. But in 2001, the terms of the contract said that upon offer of any stock in the employer. So that was forward-looking, so that she was, in fact, an employee subject to the employment contract. At the same time, she was a shareholder. And there's nothing inconsistent with that, because employees can be shareholders, employees can be officers, employees can be on the boards of directors. So therefore, it's not inconsistent.
How many cases do you have where the individual who served on a 5-person management committee and served as an officer of firm as vice president, secretary, are ruled to be employees?
Well, there aren't many, because this is a matter of new impression. And I believe that this is an appropriate case to make this decision.
So will you please, if I'm trying to ask a question, you just keep talking.
I'm sorry.
All right, thank you. I'm glad you say there aren't many cases like that. I mean, when when I was reading this, I don't, at least in my experience, I couldn't recall any cases where someone was an equal owner of the firm or had an equal number of shares and had served as the director of the firm and on the board and on a 5-person management committee and an officer of the firm and was ruled an employee. So wouldn't we be breaking significant new ground with this the whole kind of holding that you are advocating for?
Well, we may be, but I think this is an appropriate case to do that because the terms of the employment agreement say the employer may terminate the agreement without cause on 30 days notice. That never happened. The district court said that the bylaws reserve termination of employment of a shareholder to Miles Beagle's board of directors, but the bylaws constitute a binding contract as between the corporation and its members. And what this means is that the employer could terminate Ms. Lemon on 30 days notice by action of the board of directors. Now, this may be challenging. I'm sorry.
Judge Meyer, doesn't this happen in every partnership? The partnership can vote a partner out. Theoretically, the partnership dissolves and gets reconstituted, but it doesn't function that way. Partnerships all across, especially in law firms, function the same way this firm functioned. She shared in the profits. Her profit was at the risk of a profit and loss was based on the firm enterprise. Her compensation varied. She had paid in capital, and she had voted to admit other shareholders, served on the board, was the vice president. It just parallels a managing partner level of any major law firm. And it seems to me that when a partner of a law firm shares in the enterprise, shares in the risk of its success by a portion of the income, whereas an employee is usually paid a salary and made decisions for the firm, it's almost indistinguishable from the typical old-fashioned law firm partnership.
Well, it's important to note that Clackamas abrogated what was known as the economic realities test. Prior to Clackamas, there was a split of authority. The Second Circuit said that if you have a professional corporation, the people are automatically employees. The Seventh Circuit, along with the 8th and 11th, said that a partnership is virtually the same as a professional corporation. Therefore, the shareholders are owners. The Clackamas court rejected that argument. So that argument, the economic realities test, is not binding. And we need to look at the Clackamas factors.
This is a factor. I mean, the idea that somebody's in a joint enterprise and the income in that joint enterprise is dependent on the success of the enterprise, and the person has a say in the management and operation of that enterprise, seems to me you have to take all these factors into account. And I can't figure out how is this distinguishable from the traditional partnership that you're in and that I was in and that we see day to day on the street where everybody practices law. We have associates and we have partners, and partners who share in the equities and in the risks of the firm. And it seems to me here we have a person who functioned completely as a partner, not only as a partner, but as a managing partner. And it's hard to call that person an employee of herself, so to speak.
Well, I think that is a possibility here. And I do not agree that the compensation is tied to the profits and losses. And I've explained that in our reply brief. And I encourage us to take a fresh look at this. And I see my time is up.
Didn't she pay something like $62,000 for her partnership's share?
She did, yes.
isn't that a classic example of a law firm partnership?
Well, I don't think a law firm is necessarily unique, because you could have a small family-owned business, which is would be a corporation, and a person could buy stock in that corporation and still be an employee. I don't think that should be what this case turns on. It should be an analysis of the Clackamas factors without a preconceived notion that this is a partnership and the old style of business prevails.
All right, thank you very much, Mr. Seymour, and you've got some rebuttal time.
Thank you.
Mr. Philbeck? Mr. Philbeck, when you're ready.
May it please the court. As for Ms. Lemon's Section 1981 claim, the central issue relies on the juxtaposition of that claim with this court's previous decision in McCleary-Evans case, as well as the Supreme Court's decision in Schweikowitz. The Section 1981 essentially provides equal protection in the making and performance of contracts among people of all races. In her complaint, Ms. Lemon alleged that she was denied the benefit of the STL leave status, which is normally a ministerial act for those outside the protected class, as well as the defendants took extraordinary measures in requiring her to appear before the whole board of directors and present a case, get medical records that it didn't require others outside the protected class to provide, and the like. The district court actually found that Ms. Lemon was, in fact, treated differently from the others, as far as your allegations, who were white and who sought to participate in the STL plan. The question in the district court's frame was whether she alleged sufficient facts showing that the defendant's denial of the STL benefit was under circumstances giving rise to an inference of discrimination. That's the fourth factor of a prima facie case. And the court cited this McCleary case. Well, McCleary decided in 2015 the plaintiff was an African-American who applied for 2 state positions in which she was, quote, more than qualified by her allegation. She was not selected for either position. She alleged the decision makers were biased and had predetermined that they would not select, they would only select white candidates to fill the position. She didn't allege any irregularities, and significantly, she made no allegation that she was the most qualified or that the others were inferior in qualifications. So
the district court found that this fell short under Iqbal Twombly because the conclusions, because the allegations were conclusory, and you would have to show something more to indicate that the denial of some short-term leave was racially motivated, and that was hard to. The problem is that the pleading here is just what used to pass muster under the old Rule 8 standard, but that Iqbal and Twombly have required something more. And that is that there was a plausible claim that Caucasian attorneys' requests for short-term leave were granted, whereas hers was not. But that doesn't answer the question of was race the reason for any difference in treatment? That was the missing piece, according to the district court. The missing piece was the animus.
That is correct, Judge Niemeyer. But we don't think the district court considered the departures from normal procedural and substantive sequences that provide evidence of racial discrimination as determined by the U.S. Supreme Court in the Village of Arlington Heights case. We did allege that upon receiving the formal STA request, the defendants violated their own policies and normal practices. Number one, it was a ministerial decision made at the management committee level. However, the defendants with the, permitted that at the management committee level for all those outside the protected class. However, for Ms. Lemon, she had to provide additional medical documentation that was never required of those outside the protected class. And we allege that she was required to present her case with all the personal and private information that goes with that request to the entire board of directors. That's a fairly large body. It's not necessarily a few people that just need to know as it was treated in the past. And when she provided all that presentation, she submitted to a vote before the board of directors, when before it was a management committee level decision. Additionally, she alleged the racist comments that was made by one of the decision makers at least 4 months prior to the decision about her always playing the race card, quote unquote, when she had never, ever complained about race within the workplace prior to this STL issue. And we think that given that with the circumstances that given rise to the inference of race discrimination under the McDonnell-Douglas test, which is a summary judgment analysis, the Supreme Court has even said it should not be onerous. We would respectfully submit that we did raise some plausible facts in our allegations that would give rise to it being a racial animus. And
Mr. Philbeck, this is Judge Diaz. Your time is up, but I wanted to ask you about the recent back and forth in the 28J letters about Comcast and how, if at all, that changes the sort of the analysis of this claim. I mean, it appears on this record that you may have shown that racial animus may have influenced the board's decision, or alleged that animus may have been a part of it, but Comcast seems to suggest that the plaintiff has a more onerous burden to show that racial animus was the but-for cause for whatever the action was that was taken against her, in this case, the failure to grant disability benefits. So can you talk about Comcast and how, if at all, it hurts your case?
Yes, thank you, Judge Diaz. When I mentioned the mixed motive theory, I mentioned it in passing as being something that would even augment even more what the causation standard would be. I mentioned it because I knew the Comcast decision was pending, and then it went back and forth in the briefing. But I think, and clearly the court says mixed motive theory does not apply to Section 1981 claims. However, I did also raise the recent decision in Bostock, where Judge Gorsuch held on behalf of the court that but-for causes a sweeping standard. And I think that was added to the jurisprudence that the district court did not have the benefit of seeing that particular definition, because Judge Gorsuch says there's multiple causes that can support a because of or but-for causation. And so I think with the Bostock decision in explaining the sweeping standard of what a but-for can include, I think it does encompass where if we do raise allegations that could be racial discrimination, that we should have the right to pursue that in discovery to determine that whether there's a determinative factor. I hope that answers your question.
Okay, thank you.
To what degree are we allowed to consider the fact that the firm that wanted her to serve as a director of the firm and on the 5-person management committee and as an officer and vice president and secretary, how likely is it someone that that a firm that has had her as part of its decision-making councils is motivated here by racial animus? It seems to me that that the two claims are not the Title VII claim, the Section 1981 claim are not unrelated, because this is a firm that appeared to want to give the plaintiff every chance and to have her as a part of the decision-making process.
Judge Niemeyer, I'm not sure that I would agree that the firm reached out and tried to make her part of the decision-making process as you know, as stated in the allegations. I think to the contrary, you got the Title VII issue where she was excluded and was arguably efforts to make her to quit or resign or be fired under the Title VII analysis. But then later, months later, comes the Section 1981 issue with the STL leave. And granted, it could be related to the Title VII as well, if she's found to be an employee. But aside from that, because of how they treated even cited alleged example of a white employee who was not qualified, but yet was allowed to participate in the STL program, right there, that's a race issue, and we should be entitled to explore that to determine in discovery whether that was a determinative factor.
Thank you, Mr. Philbeck. You said that you've called me, this is Judge Wilkinson, you've called me Judge Niemeyer several times, and I want to say how flattered I am.
I apologize.
No, I want to say how you flatter me. I'm happy any day of the week to be confused with Judge Niemeyer, for whom I have the greatest degree of respect.
You notice that I remained silent because I thought that were very good.
Understood.
All right, thank you very much for your argument, and let's hear from, is it Mr. Shadd?
Good morning, Your Honor. It's Ms. Shadd. Thank you.
Excuse me, please. I'm sorry, Ms. Shadd.
No concerns at all. Thank you. Good morning. Your Honors, along with my colleague Isaac Lenartz, we represent Myers-Beagle and its former managing partner, Ms. Lynn Borchers. I'm going to address the Title VII issues, and Mr. Lenartz will address the Section 1981 issues. Your Honors, to cut to the chase, if the allegations in this case are sufficient to confer employee status under Title VII on an equity shareholder owner of a 25-member law firm, then Title VII coverage is going to be the rule for shareholders and partners in law firms and other professional service firms, rather than the rare exception that courts and federal agency have to this point deemed it to be. And to respond, Judge Niemeyer, to your question and to your comment, there is nothing distinguishable about this case and these facts and this arrangement between Myers-Beagle and Ms. Lemon from the traditional partnership that I'm in, that you all have been in, and we are not aware of any case where on facts like these, a party has been found to be an employee. And Judge Wilkinson, you asked if this would be a shift, would break new ground. Well, with all respect, it's not just going to break new ground. It will be a seismic shift in the law in this area. So it is our position, and Your Honors focus properly on exactly really what we believe are the outcome determinative, undisputed, alleged by Ms. Lemon facts. And there are, 10 or 11 of them that she simply cannot overcome. She was an equity shareholder for over 9 years.
Ms. Shadd, can I interrupt? This is Judge Diaz here. So I wanted to say that so I wouldn't be confused with my two colleagues up front, both of whom I have great respect for as well. So with respect to the employment agreement, is it your position that once Ms. Lemon signed the shareholder agreement, that the employment agreement was null and void? And if so, where is that indication or evidence in the record?
Thank you for the question. It is our position that when she became a shareholder in January of 2007, that she was no longer an employee. The shareholder agreement itself it does have a merger clause in it, that this is the entire agreement between the parties provision. So there is that in the original shareholder agreement that she signed in 2007. In 2009, she and the 19 other shareholders signed a modification to the original shareholder agreement that removed every reference to employee and employment with respect to shareholders. That was the sole purpose of the modification, by the way. That's in the record. And then in the facts of what actually occurred after she became a shareholder. As a shareholder, she could not be fired just because somebody wanted to fire her. She had a protection that she could only be fired by a vote of other shareholders. So she was not subject to termination as she had been previously while an associate lawyer at the firm. She did not own any part of the firm. She did not get a vote on any issue of the firm's business. As an associate, she knew what she would make every year. As a shareholder, when the year started, they had maybe some idea what they might make, but they could make more, they could make less. They could go into the negative. That was possible. That's classic equity partner in a law firm structure. So back to the direct question, Judge Diaz, the 2001 employment agreement did not continue to apply, and it certainly wasn't relied on, used, referred to. And I think in their reply brief, appellants even say that there was never any exercise or even attempted exercise of authority under that agreement. I mean, as I
Well,
I mean,
go ahead, Judge
Diaz.
Wilkinson. Go ahead.
You go ahead.
Okay, thank you. Your colleague on the other side, I think, concedes, perhaps, maybe he doesn't, that there was no actual attempt to control, although maybe not fully. But he makes the point that it's not just whether or not there was an actual attempt to control, but whether or not the governing documents gave the employer the authority to do so. And he points to a number of provisions in these various agreements. For example, the provision that allowed for review of her work as a shareholder, which I think applied to everyone. The fact that the agreements indicated that Ms. Lemon was required to use her sole and exclusive efforts and for the benefit of the firm. The fact that the partner in charge of the chair of the board of directors, who's a defendant in this case, essentially had sole authority for managing the firm and effectively had veto power over decision making in day-to-day operations. And I know you dispute that, but her point is that even if the firm chose not to exercise control, that the record evidence in this case at least suggests the ability to control.
Yes, and thank you for that question. There is no case that says that the reserved, unexercised right to control is sufficient. All of the cases include allegations of actual control. Even the case that appellant cites for this proposition, the Browning-Ferris case, says that it's an unexercised right to control is a factor. It's a factor. But they specifically say that in that case, they weren't even deciding whether reserved but unexercised authority alone could actually be sufficient. And that was a joint employment case under the National Labor Relations Act. But so there is no case where a unexercised right to control is legally sufficient to confer employee status. No case that we found anyway, and no case cited to us.
Well, it seems to me that if each of us reflects on the real world, every law firm has built-in aspects to manage conflicts of interest, where the firm controls whether a particular partner takes a case. over malpractice type of issues, over the control that a particular partner exercises over whether to protect against statutes of limitations and that type of thing, over shared clientele where the partners want to have a say in somebody else's because of client relations. It seems to me inherent in the nature of a partnership is the collaboration in delivering professional services. And the test is a little bit whether the person at issue is working for the partners or is working with the partners to carry out the enterprise and shares in the risk of the enterprise. Indeed, the Supreme Court's Baccamus case provided that one of the important factors in making the determination is whether the individual shares in the profits, losses, and liabilities of the organization.
Yeah,
I suppose all those factors are applicable here, like in the law firm.
Yeah, Judge Niemeyer, I couldn't agree with you more. That's exactly right. I mean, and context matters. The fact that this is a law firm matters. It's not a widget company with line manufacturing employees. It's a law firm, and yes, and we've cited cases for the proposition that just because a partner has another partner weigh in on their work or even tell them to do something differently doesn't make that first partner an employee. I mean, you know, if I, as the senior partner on this case, didn't like something that Mr. Lenart's put into the brief, I'm going to take it out before it's filed. That doesn't make him an employee. I mean, that's just the nature of the profession. It's the way we work together. It's the way law firm partnerships operate. And our position is that the facts in this case, as alleged, which are undisputed, legally require this outcome of dismissal. She cannot overcome these facts. There's no question that she shared in the revenues and the profits and the losses. I mean, look at the formula; it's right there. And again, Judge Diaz, back to your question. You know, the fact that there was a quality control policy in place, you're correct. That's a policy that the firm of which she was a member and a voting member put in place that applied to everybody. And it only makes sense. This is a patent law firm. It's high risk. It's hyper technical. You know, the fact that lawyers reviewed other lawyers' work before it got submitted, you know, that's a great risk management tool. You know, you would see the same thing in securities filings, I'm sure, where you've got high risk and hyper technical law being practiced. So there is nothing unusual about this relationship. And she has not pleaded any facts that undermine the facts that we're relying on.
That's the problem that I have, is that I don't see limiting principle to this. And if we were to sustain claim, I think that there would it would be arguably applied to every law firm in this country, because the arrangements here are so completely typical. There's no way to cut it off. There's no distinguishing principle that distinguishes a law firm from every other law firm. And this is, if you were looking for a sort of a prototypical description of how a law firm normally operates, you would look at this case.
Yeah, Judge Wilkinson, I couldn't agree more strongly with you. And I do think that there really is no way to limit this, and the floodgates will open, and it's not at all what Title VII was intended to apply to. And I just think it would be legally incorrect, just flatly incorrect.
I suppose in this changing world of law practices, we now have non-equity partners, and other of-counsel relationships that could blur these factors, but that is not what's presented in the allegations of this complaint. But I just make that notation because there are associates, there are super associates or non-equity partners, so to speak, and there are of-counsel lawyers who provide more limited input to the firm, and all of those might have to be addressed differently if that case came. But in this case, of course, Lemon is a typical partner and a managing partner of a law firm. Seems to me most of the aspects she alleged are repeated throughout the law firm community.
Yeah, Judge Niemeyer, I think that's right. I think there are a subset of cases that could potentially effectively be brought by non-income partner or non-equity partners, income partners of counsel, associates. For sure, that's not this case, though.
And also, I'm not suggesting that they would be employees. I'm just suggesting that they would, the circumstances of those relationships might blur, might be more difficult to apply.
That's right. They may well be able to survive a Rule 12b-6 motion. Yes.
Ms. Shad, this is Judge Diaz. One additional question. So the one area, I suppose, where this case, at least according to your opponent, is suggested is close to the Sidley Austin opinion, where we had this self-perpetuating executive committee that essentially co-opted power onto itself, and at least according to that opinion, effectively made the partners outside of the committee partners in name only. And your opponent on the other side says that, at least in some respect, the situation here wasn't that much different because of the sort of the extensive influence of Ms. Borchers in the day-to-day operations of this firm, which they allege effectively negated the authority of the other partners. Could you speak to that?
Yes, sir, and thank you for the question. First of all, I don't think there are sufficient facts alleged, only conclusions that Ms. Borchers controlled anything. In the Sidley case, the self-perpetuating board, they were not elected. That's not the case in this situation. Ms. Lemons had a vote on everything. The self-perpetuating committee in Sidley determined compensation for everybody else and didn't tell anybody else how they got there. It was all secret. That's not at all the case here. And we've cited cases in our brief, a number of them, that stand for the proposition that the really critical question in these cases is, does the partner have the right to vote? In this case, it's undisputed that Ms. Lemons had the same right to vote and exercise that right to vote as every other owner in the firm. The fact that her vote didn't carry the day, that she didn't like the result, that she didn't persuade others to vote the way she voted is inconsequential to the legal question of control.
And on I've had the good fortune of serving in my prior life and on several boards of directors, and there's always it's never a question of equal control. I mean, it's never a completely equal situation because every board has an executive committee, and the executive committee is, the board may be 15 or 16 or 20 members, and the executive committee may be 4 or 5. And the executive committee is a mechanism that is employed in order to bring about efficiencies and to avoid what are the sort of unwieldy characteristics of management through a 15 or 20 person body. but I've never thought that the creation of an executive committee or a management committee or whatever introduced a degree of inequality, for example, such as to make board members who were not members of the executive committee somehow persons of second-class status or employees. I mean, that is just the way firms operate, and the way boards operate. That the executive committee makes an awful lot of day-to-day decisions, and then when something is really important, they take it to the full board, or they may seek a ratification before the full board or whatever. But this again strikes me as a prototypical kind of thing, and the fact that some people may be on the inside of a board or relatively, or that a small group may have influence, that's just that's just standard operating procedure, isn't it?
Yes, sir. That's life. I mean, that's just the way it is. That's and in this case, unlike some of the cases involving law firms, Ms. Lemon actually had an equal vote. She didn't have a lesser vote than somebody else who maybe was a more important or more powerful partner. They all had one vote, one equal vote on everything. And she alleges, and it's undisputed, that the business of the firm was conducted by the board through the management committee, but ultimately by the board, of which she was an equal and participating member at all times since 2007.
All right. Do you have anything to add, Ms. Shadd?
No, sir, other than to say that I think Judge Flanagan was 100% right on this one.
All right. Do either of my colleagues have any questions? Judge Niemeyer, Judge Diaz, do you have any questions?
I think we've covered Ms. Shadd's position well.
I do not. Thank you, Judge Wilkinson.
I think you're up next. Would you like to come forward and give us your argument?
Good morning, Your Honors, and may it please the court. Isaac Lenartz on behalf of the Appellees Myers-Beagle and Lynn Borchers. Under Section 1981, plaintiff had the burden of pleading that race discrimination was the but-for cause of the board of directors' decision that she was not qualified to invoke the firm's STL plan. As an initial matter, there are no factual allegations that Myers-Beagle's former managing partner, Lynn Borchers, did anything that caused plaintiff's STL request to be denied, much less that she did so based on plaintiff's race. In fact, there are only two areas where plaintiff's factual allegations about her STL request touch on the issue of race, and neither of those connects the dots in a way that plausibly suggests race discrimination. First, plaintiff alleges that 4 months before the STL decision by the board, one shareholder in the firm told another shareholder that plaintiff, quote, played the black card too much, unquote. That alleged comment, however, does not support an inference of race discrimination. It was a single comment made by one shareholder to another shareholder. And there's nothing in the complaint that plausibly links that comment to the decision by the full board by a 17-3 vote 4 months later to deny plaintiff's STL request. And in fact, plaintiff herself, in paragraph 78 of the proposed amended complaint, alleges that this comment was made in a different context and that the reason it was made was to retaliate against plaintiff for having reported gender discrimination during an investigation conducted by outside counsel. The second point that the plaintiff raises race in relation to her STL request is she says she was qualified to invoke the STL plan, but her STL request was treated differently than requests made by white shareholders. She says she was put through a more rigorous process and her request was denied, while white shareholders had their requests confirmed by the management committee. We see three problems with those allegations. First, plaintiff has not pleaded any facts showing that she was qualified to participate in the STL plan. The district court assumed without deciding that she was qualified, but there's no reason for this court reviewing de novo to make that same assumption. If plaintiff was suing under the ADA, she could not just allege that she was a qualified individual with a disability. She would need to allege some facts about what that disability was. The same thing is true here. If plaintiff was not qualified to participate in the STL plan, and she hasn't alleged any facts showing that she was, she has not been deprived of any benefit and thus has no Section 1981 claim. Second, plaintiff has not pleaded sufficient facts to permit a meaningful comparison between her situation and the white shareholders who made STL requests. To draw meaningful inference about different treatment, you need similarly situated comparators. You need an apples to apples comparison. This court's Leitner decision, which is cited by the district court's decision at Joint Appendix 502, makes that exact point. It says the similarity between comparators must be clearly established in order to be meaningful. There are no factual allegations about what plaintiff's alleged health condition was, so it's impossible to say whether she was similarly situated to the shareholders who she compared herself to, who invoked the STL plan for cataract surgery and other illnesses. There are also no factual allegations to support her conclusory allegation that one shareholder was allowed to invoke the STL plan, even though that shareholder was not qualified under its terms. We don't know who that shareholder was, what their reason for invoking the plan was, or why plaintiff thinks that doesn't align with the plan's terms. Because of that, it's impossible to draw any inference about whether different treatment the plaintiff alleges was because of her race or for some other reason entirely. Then third, plaintiff herself alleges plausible alternative explanations for the denial of her STL request that have nothing to do with race, specifically gender discrimination and retaliation. In particular, plaintiff repeatedly alleges that her STL request was subjected to rigorous review and ultimately denied because the firm wanted to retaliate against her for participating in a gender discrimination investigation. Those allegations undercut plaintiff's claim that race discrimination was the but-for cause of the STL decision and further distinguish her from the alleged comparators. The bottom line is that nothing in plaintiff's complaint pleads a plausible claim that race.
Mr. Leinertz, excuse me, Judge Diaz here. Are those explanations necessarily mutually exclusive? The fact that, she alleges that, I assume she would say that she alleges that part of the reason why her benefits application was denied was because she was engaged in this investigation of gender discrimination, but that doesn't necessarily exclude a possibility that the firm also racially discriminated against her, does it?
Judge Diaz, I think that's right. I don't think it necessarily excludes the possibility that there was another cause, but what it does is I think it undermines the idea of a comparison. So she relies on comparator evidence, and what makes a comparison possible is when you have similarly situated parties, the plaintiff inside the protected class and the other parties outside the protected class, and they're similarly situated, so you can infer that the alleged wrong was because of the class difference, the fact that plaintiff was in the protected class. Now, plaintiff has alleged in some factual detail that there's a wholly different reason, not related to race, that she might have been treated differently than those comparators. And so I think it undermines her reliance on comparator evidence.
What do you say was the reason?
Go ahead, Judge Wilkinson.
Oh, did I interrupt you, Judge Diaz?
No,
if
sir.
I did, go ahead.
Okay, well, thank you. Just to follow up, at the very beginning of your argument, you talked about Comcast and but-for causation, and I don't know that you had a chance to respond to the 28 J letters that were submitted in this case, but your opponent on the other side says there's been a gloss on Comcast via the Bostic case that suggests that it's not necessarily the case that you can only have one but-for cause of a discriminatory act. And so my question to you is does that in any way change the result in this case if we accept that premise?
No, Your Honor. I think that Comcast says that you have to have but-for causation in the Section 1981 context, and I agree that Bostock does discuss the possibility that you can have more than one but-for cause. At the end of the day, though, there's not enough alleged, even looking just at the allegations about race, to say that race was the but-for cause of plaintiffs, of the denial of plaintiff's STL request in this case. So we're still in the area where it's conceivable that decision was made for a variety of reasons, because of race, because she was not qualified under the STL plan's terms, we just don't know, because her health condition was substantially different from the alleged comparators, because of gender, in retaliation for participating in the gender discrimination investigation. So I don't think that it changes the result in this case.
What ways was she not qualified for the short-term leave? Why was she disqualified?
I don't think we know from the complaint. She says that she was qualified and that she was denied, but she never alleges what her health condition was. She says that she experienced numerous events which qualified her for participation, and 2 additional independent qualifying events were being experienced by her immediate family members. But she never alleges what her health condition was or what was going on with her family. And so it's not possible to compare those health conditions and family circumstances, whatever they were, with the language of the policy itself.
What would she have to allege with respect to a health condition qualify her for the short-term leave?
I think, Your Honor, if you look at Joint Appendix 373 that has the qualifications for participation in the STL plan, the qualifications include prolonged physical or mental illness suffered by the shareholder for which leave is recommended by a physician, family leave, maternity, paternity leave for birth, adoption of a child, and prolonged serious illness of an immediate family member or other protracted family emergency that imposes a substantial burden on the shareholder.
All right, was that none of that was alleged in the complaint?
None of that is alleged in the complaint. All she says in conclusory fashion is, I was qualified. And so there's no way to evaluate whether that's...
but the particular health condition is not alleged?
No, Your Honor, and that's information that the plaintiff should have in her possession. She knows what her health conditions are and had the ability to allege that and chose not to.
One other question. I mentioned to Mr. Philbeck that I thought, looking at the totality of the circumstances here, maybe the Title VII claim and the 1981 claim are not unrelated, because it was hard for me to see how racial animus was behind a denial of a leave request from a director when she was brought onto the board and really served in what at least on paper seemed some positions of real responsibility within the firm. I don't think that a racially motivated firm would be welcoming plaintiff into a position on a management committee and as a vice president and secretary. I mean, it just seemed to me that the overall record here, although there may have been a falling out at some point, but it seemed to me that the motivations were altogether laudatory, and that they wanted her to be a part of the decision-making council. As I say, there may have been a falling out. Obviously, there was with the 17-3 vote. But there was an effort here, at least on the part of the firm, to make its governing structure more diverse and more inclusive. And that was a good thing. And I wonder if we can take that into account as one among multiple factors bearing on the 1981 claim.
Yes, Judge Wilkinson, I think you can take that into account. I mean, it's been alleged and it's before the court. She was elected to the partnership and given, officer positions. In 2016, she was the vice president and secretary. She'd served on the management committee. And while there are other allegations that suggest a falling out, there's no suggestion that it had anything to do with her race, which is the crucial question for Section 1981. The other thing I'll say is the 17-3 vote by the board. We just don't know, what the reasoning for that decision was, because we don't have any information about her alleged qualification for the STL plan. And so it's really difficult to evaluate whether that's reflecting some sort of falling out or just a reasonable decision based on what the circumstances were.
Do you have anything further, Mr. Lenartz? Mr. Lenartz?
No, sir, not unless there are other questions from the court. We request that.
I'll ask my colleagues if they have any further questions. Judge Niemeyer, Judge Diaz, do either of you have further questions you would like to ask?
No, I have none. Thank you.
I do not. Thank you very much.
Thank you.
Mr. Seymour, you've reserved some time for rebuttal, and we'd be happy to hear from you.
Have one rule for law firms and a different rule for all other businesses. It should have the same rule for all forms of businesses. The test should not be, does this look like an old style partnership? The test should be, is there a master-servant relationship that shows that the individual is actually an employee and not a partner or a partner-like thing? Justice Ginsburg observed that there is nothing inherently inconsistent between the coexistence of a proprietary and an employment relationship. You can be both an employee and a shareholder, an employee and a director, an employee and an officer. So that should not be the test that this court adopts. There's nothing in the record. I'm sorry.
She was only able to get one other vote.
Well, if we look at two things, number one, the right to control, Section 16 of the employment contract is sweeping in that she agrees to observe and comply with personnel policies, operating policies and procedures, and all other rules and regulations, and to carry out and to perform orders, directions, and policies stated by the employer from time to time, either orally or in writing. That's not ambiguous.
Mr. Seymour, what's your response to the argument that the shareholder agreement had a merger clause in its initial form and then later was amended to eliminate the use of the word employee because it inaccurately described the relationship? That was the argument, I think, presented by your colleague.
I don't see the merger clause, Your Honor, but as I understood, and as I read the...
when you say you don't see, what's that mean?
Well, I think the contract has a merger clause. But
no, I'm talking about the shareholder agreement.
Well, the merger clause would not act to terminate an employment contract.
Of course it would. I mean, if it says this is the entire contract between us and it says supersedes all other contracts, it ends the employment contract. That's the position that your colleagues, that Myers-Beagle is taking.
Well, we dispute that, Your Honor. And
well, that's what I'm asking you. How do you dispute it? What is your argument?
That the employment agreement needed to be enforced because, well, I apologize, Your Honor. I don't have a response to that at this point. If I
Or is
may,
there anything further you wish to add, Mr. Seymour?
yes, I would like to indicate that Ms. Borchers exercised her authority in such a way as to establish herself as Ms. Lemon's direct report, and through that relationship, supervised her. And here's an example. In the October 19, 2016 meeting of the board, Ms. Borchers ordered Ms. Lemon to leave the meeting, and Ms. Lemon thereafter obeyed and left the meeting. What this demonstrates the power balance between a master and a servant. The power dynamic can be interpreted two ways. One,
How is that distinguishable from any board of directors which excludes a member who is the subject of the discussion? That's a traditional function in a partnership meeting or in a board meeting, that when the subject to be taken up is about a partner. I can recall when I was in our law firm, we had a very serious malpractice charge against a partner, and we didn't quite know how to approach it. We excluded the partner from the meeting and discussed it. Now, it seems to me that would be just ordinary protocol.
well, I don't think we ought to read it that way, because this is one example of a pattern in practice that marginalized Ms. Lemon, so that if we look at how she was treated generally, then we see that the corporation had the power to set the rules and regulations, and Ms. Lemon had to report to someone higher up in the organization and had little, if any, ability to influence. And what this means is you need to take the Clackamas factors and look at each one of them, and not just look at the form of the business as a partnership, but look at the way that the partnership, this organization operated. And if you do that, factor by factor, I submit that you will find that there is ample evidence to support a finding that Ms. Lemon was an employee.
All right, thank you very much, Mr. Seymour. Judge Niemeyer, Judge Diaz, do either of you wish to question Mr. Seymour further?
No, I'm fine, thank you.
I don't. Thank you very much.
All right. Thank you very much, Mr. Seymour. Mr. Philbett?
Yes, sir, Your Honor.
You've reserved 1 minute of time for rebuttal.
Thank you. In that time, if I could just make two key points, I think. Number one is that we did allege that Ms. Lemon was qualified for the STL plan. The court assumed it, and we actually have allegations where she experienced numerous events throughout 2016 that qualified her for the STL leave participation. She notified Borchers throughout that year that she was experiencing the qualifying events, that's alleged, and at no time did Borchers ever question the seriousness of Lemon's qualifying events or the question of their legitimacy. And then even most importantly, Borchers followed up with Lemon periodically to determine that Lemon was still in fact experiencing the qualified events. That can be construed as an admission right there. Secondly, on the issue of the causation, yes, we do rely on comparative evidence, which we stated there was an employee not of protected class who did not even qualify, but yet was provided the STL leave. But more than that, and this is what's missing from the opposing counsel's commentary, is that there was no mention about the procedural and substantive departures of the policy that was followed and or not followed for Ms. Lemon, but was provided to the others. Just because a firm reaches out and gives the outward appearance that it's recruiting females or it's recruiting African Americans and it puts them in leadership roles doesn't mean necessarily that they won't discriminate against, say, a female or African American if they become pregnant and need leave. So just because there's an outward appearance of one doesn't necessarily mean that this immediate question of whether she should be granted STL leave, all of a sudden there can't be racial discrimination because, well, they come across as a pretty good and cooperative employer with racial equity. That's not necessarily the case here. If we look at the focus of why that was.
Mr. Philbeck, all I was suggesting is we don't want to put ourselves in the position of penalizing firms that make altogether laudable efforts to move toward inclusion and toward diversity. It seems to me that those sorts of efforts, as laudable as they are, should be credited. And that's all I'm worried about, is that I just don't want to penalize those law firms who are trying to do the right thing.
I understand, Judge Niemeyer, and what I would say is that should be fleshed out on a summary judgment question where both sides proffer their evidence, and then there could be a decision made by the trial judge whether there's a genuine issue there.
All right. Thank you very much, Mr. Philbeck.
Yes, sir. Thank you, Your Honors.
All right. We will we'll adjourn. We'll recess court, and we'll move directly into our next case.
Good morning, Your Honors, and may it please the court. Matt McGuire on behalf of Appellant National Veterans Legal Services Program, or NVLSP for short. The district court erroneously dismissed NVLSP's complaint in this case because it wrongly found, one, that NVLSP lacks standing under Article 3, and two, that NVLSP had not alleged an agency action reviewable under the APA. The district court's errors on both prongs of the analysis are fundamental, and they flow directly from the district court's failure to properly identify the claims that NVLSP brought in its complaint. Specifically, NVLSP had two potential claims to bring under the APA. The first bucket of claims would be where the government completely fails to comply with a mandatory and discrete legal obligation. The second type of claim would be where the government has taken too long or unreasonably delayed in complying with its mandatory and discrete legal obligations. Both types of claims are actionable under the APA, but NVLSP alleged the first one, and that's what makes this a relatively straightforward case. On January 2nd, 2020, when the complaint was filed and the allegations in the complaint were laid out, not a single decision of the boards was available publicly on a centralized internet website that would allow NVLSP or others to isolate cases of interest. That set of facts is what makes both the standing analysis and the agency action analysis relatively straightforward. With respect to standing, NVLSP's allegations fully satisfied the standard for an informational injury articulated by the U.S. Supreme Court in FEC versus Akins, Public Citizen versus United States Department of Justice, and this court's decision in Dreher. This court and the Supreme Court have consistently held that a plaintiff suffers an injury in fact when it's denied information that must be disclosed to it pursuant to a statute. To show informational injury, NVLSP needed to allege as follows. One, that it lacked access to information to which it was legally entitled, and two, that the lack of access to the information created a real harm with an adverse effect. And both pieces of that analysis are satisfied in the complaint filed in this case. On the first prong, NVLSP alleged that 10 U.S.C. 1552A5, 32 CFR 70.8L, DoD directives, and DoD instructions all gave NVLSP the right to access the board's final decisions in the manner it alleged. And on the second prong, NVLSP detailed how it relies on its ability to access those decisions and how it's critical.
Where you deny the information because the information, as I understand it, was always available on a specific request, and I don't. Correct me if I'm wrong, but I don't remember you identifying any particular request that was actually denied. And in light of the fact that we don't know that any request was denied, and apparently you were able to get the information you wanted on a specific request, is there really a deprivation here?
Judge Wilkinson, I have several responses to that. The first being that there is no allegation by NVLSP that it had the ability to obtain that information through a specific request. And I think that's critical, Your Honor, because that's a fact that the government is trying to bring into this case at the motion to dismiss stage. And we raised in our briefs and below that if they wanted to have a factual challenge to standing, that our claims are not true in the complaint, that we could have gotten this information through a specific request, then we should have had a hearing, or at least the district court should have considered the declarations put in related to the preliminary injunction in reviewing the accuracy of that information. Because my second answer, Your Honor, is that that is not true from NVLSP's perspective. As the declaration around JA 4547 shows, NVLSP was unaware that it could make a specific request, that its specific request would not have solved its injury in this case, because NVLSP looks at the full body of decisions to provide a resource manual and other resources to veterans advocates and veterans themselves. So it's not as if they know we want exactly this decision. And there are also declarations that were submitted around the preliminary injunction showing that the department's workaround process that they rely so heavily on didn't work at all.
Well, you're going to have access to the body of decisions, just not as quickly as you want.
Well, Your Honor, again, to return sort of to my first point, and I do think it is important, is that that is not alleged in the complaint. When the complaint was filed, NVLSP's allegations, and the truth is, had no idea if these decisions would be available again, or when, or if, or in what form. We have since learned, as a result of this case, that the department has its own reasons that it wants to explain why it took them down and why it's putting them back at the rate it's putting them back. But
well, were they really the department's own reasons? I thought it was under a statutory directive to redact sensitive private information, and that it's caught between two obviously desirable goals. One is to make the full information available to the public, but on the other hand, when you're talking about the discharge from military service, and whether one has a honorable discharge or general discharge, or I think there are 5 different classification levels. It's hard for me to think of anything that's more sensitive than that, because particularly if it's something other than an honorable discharge, any future employer would want to know. And I mean, this gets to the point of where something could really compromise a service member's life prospects in a very serious way. And Congress at least took that into account and said that they didn't want very personal and private information out there. So in complying with this dual mandate, the agency wants to move with real care, because I could see it being sued if inadvertently personal and private information of an embarrassing sort, or a questionable sort, or a disputable sort was made public. I can see a flurry of lawsuits resulting from that, because that just seems to me very sensitive stuff. Somebody could there could be information about post-traumatic stress problems, information about don't ask, don't tell, information about alleged sexual assaults and this and that. I mean, it would cover the waterfront. And so it just seems to me that the agency was not only right to proceed with some care, but it was obligated by both statute and regulation to do so.
Judge Wilkinson, if I may, I have a variety of responses to that I hope will alleviate some of those concerns. The first is that NVLSP fully agrees that it's important to have this information redacted. But I want to be clear that the redaction obligation is not as broad as sort of laid out in your question. They're redacting personally identifying information. So we're talking about people's names, their social security numbers, very sensitive information, but nothing that would imply the discretion to redact things that Your Honor was described where maybe they feel like something is too sensitive or not sensitive enough. They're limited to sort of core PII redactions. And so we see that as just another sort of ministerial requirement, and it's a duty they owe to veterans. And it's very important, Your Honor, from our perspective, given the fact that this case arises to the court on a motion to dismiss, that the court look at the framing and the allegations in the complaint with respect to the redactions.
Let me ask you about that. I thought it was the record was developed because there was a motion for a preliminary injunction, and in considering the motion for a preliminary injunction, which included a record and which the court can consider, it concluded that there was no standing, number one, based on the record before the court, and number two, there was no final agency action, therefore no jurisdiction to handle it. And the court relied on both prongs based on the record. We're not under a 12b6 failure to state a claim. We're talking about standing, which is a court decision to make, and jurisdiction, which is a court decision to make.
Judge Niemeyer, respect.
The court can look at anything in the record to support those things.
Judge Niemeyer, that's not what this court said in the Wikimedia Foundation as it laid out the standard of review applicable to standing. And then second is that I disagree with Your Honor's characterization of what the district court did here. The district court addressed both the preliminary injunction and the motion to dismiss in the same order, but the court put blinkers on when it came to all of NVLSP's evidence in the record and addressing standing, if that is what it did. For example, if the court looked at JA 47, paragraphs 10 and 11, NVLSP pointed out a specific instance where it was unable to carry out its projects with its partners as a result of the government's actions in this case. So to the extent
that you can argue that on the standing issue, my whole comment is that you're treating this like a 12b6 where we have specified rules. This is a challenge to standing, your standing, and I think you make some valid points on the standing issue. But the court decided that you didn't have standing, and the court also decided that if it was wrong on that, it nonetheless had no jurisdiction to rule. And it based that on the fact that you were challenging the agency's efforts to fulfill its responsibilities, and that kind of a challenge is not challengeable under the APA.
Judge Niemeyer,
that's what the district court did. That's what the district court said. Now, if the district court didn't consider something, you can argue that. But the holding of the district court was those two things.
Judge Niemeyer, respectfully, we disagree with that framing of the district court's opinion. If you look at the court's order, it just addresses the motion to dismiss. It cites the motion to dismiss standard of review itself and its analysis. And at the very end, it says it's not addressing the preliminary injunction at all because it lacks jurisdiction. And this court has made very clear in Wikimedia Foundation that there are different rules that apply to a Rule 12b1 standing motion or at any other sort of jurisdictional issue, depending on how the defendants have argued it. And here we think that the proper approach is to look at this case on the facts of the complaint, since it was a motion to dismiss that was granted, and we did not appeal the denial of the preliminary injunction.
McGuire, this is Judge Diaz. Sorry to interrupt, but just following up on Judge Niemeyer's question, I get your point, for example, that if the agency in this case, if the facts had been, as you allege initially, that the agency simply had failed or abdicated in its obligation to set up this virtual reading room, that would amount to a discrete agency action. But I don't think that we should put blinders on to the reality. In fact, I suppose even absent an allegation in the complaint that we could take judicial notice of the fact, and of course it's in the record because of the preliminary injunction proceedings, that the agency has begun to comply with its obligations to put together this virtual reading room. It's just not doing it as quickly as you and your agency colleagues and the people you serve would like, and that's understandable. But are you saying that we simply we just have to turn a blind eye to that in fact the agency has acted?
Judge Diaz, my first order answer would be that the better approach to this case, because of the motion to dismiss, is yes, because it invites the government to come in and do exactly what it did here, which is instead of answering the complaint and we could have moved to summary judgment, they could have made clear that this is an unreasonable delay case. We could have tested the veracity of some of these assertions that the government is making. Instead, they put it in through declarations and around a PI and then relied on it in a motion to dismiss to get facts in the record. My second order.
When you clear all that away, the basic complaint remains dissatisfaction with the pace of compliance. I mean, if they've apparently 138,000 of the 245,000 decisions have been posted. So there is an effort to comply going on. It's just not proceeding at the pace that you would find desirable, and there must be hundreds of agencies around Washington, hundreds of federal agencies that are not proceeding as quickly to comply with a statutory mandate as the recipients of that information, or as the beneficiaries of the statutory mandate will almost inevitably, in the nature of things, be frustrated with the pace that the government is is moving. But I wonder if there isn't a real separation of powers problem at the heart of all this, and that is what you're urging us to do is to jump right into the middle of the agency's compliance efforts and to say this is not going fast enough, or you're proceeding to do this in the wrong way, and maybe we would have to set deadlines for and the rest. In other words, it's a real there are all kinds of landmines to this, and the upshot of it would be a serious infraction of the separation of powers, because we would be assuming for ourselves the performance of an administrative function and essentially an executive branch function. And all of the courts that I've read on this decision about what is a final agency action under the APA, they all envision something far less open-ended, don't they, than what you're inviting the court to do. I mean, Judge Diaz gave an excellent example at the beginning of the argument about whether the agency was saying, well, we're just not going to make anything available. But that's not what's going on here. But why? I mean, again, my question is, you're asking us really to overtake or to assume the general programmatic functions of the agency, and that gives me a real problem from a separation of powers point of view.
Judge Wilkinson, I have a couple of responses. I'm going to try to boil them down quickly into one legal and one factual, if I may, since I see that my time has expired. On the broader point, I'm going to answer this question on the assumption that the court is going to look beyond the four corners of the complaint, despite the motion to dismiss posture. On the legal side of it, Your Honor, I think the answer to your question is, if you perceive a separation of powers concern about overseeing agencies and how quickly they do undertake actions, the APA explicitly, textually provides for that cause of action for unreasonable delay. The DC Circuit has been doing this for the last 30 years. The track factors were briefed below related to what constitutes an unreasonable delay. And it is, in fact, a rule of reason test that courts routinely apply to decide.
Well, that may be an unreasonable delay for a discrete agency action, But what you're talking about is unreasonable delay across the breadth of a program. Now, you know, if you're talking about an individual plaintiff seeking an individualized piece of information or whatever, there can be maybe a place for an unreasonable delay action there. But the unreasonable delay question that you posed is still subject to the final agency decision requirement. And if there's no final, it's the final agency action requirement that separates an individual claim for an answer from programmatic supervision.
Judge Wilkinson, I couldn't agree with you more on that, but there is nothing more discrete or limited of an agency action than a publication requirement. That's all that we're talking about in this case, is a publication requirement. We're not talking about what goes into the decisions. We're not talking about how quickly they render the decisions. We're not talking about anything except for they have decided a case and they have a statutory mandate to publish that decision and to the world.
I thought the record shows that they did not make a decision to deny that responsibility or to carry out that obligation. What they basically are saying is they have this dual duty to publish and to scrub the decisions of personal information, and that they have taken down the decisions to scrub them and put them back up, and they're now about halfway done. And they're continuing to do it. They're not denying it. They're just carrying out their functions. And your challenge is, while they're doing that, they're denying you information. But that's a challenge to the performance of the program, it seems to me.
Judge Niemeyer, to the extent that we're going to look at what they have done since the complaint was filed, that would be the unreasonable delay side of the challenge, that they took down 245,000 decisions. If we look at what they have now put in the record for redaction-related reasons, what the district court should have done is gone forward and said, okay, well, you have multiple agency actions going on here. Have they been unreasonable in delaying how long it takes them to publish the cases?
But the point that Judge Wilkinson was making, I believe, if I understood it correctly, is let's grant you all of that. They were unreasonable in their delay. They did not do it in the best way. They took down all the decisions in a group and are putting them back, and it's taking way too long. And in the meantime, you're being denied the information you want. That all is, if it's all accepted, it still comes down to criticizing the agency for the way it's managing the program. The agency has never said, as far as I can see, that you're not entitled to that information. They basically said, we're trying it in their own clumsy way. And that's your allegation, and maybe they are clumsy. I mean, it sounds to me like it's taking a long time to get that stuff back up, but their response is they're scrubbing the decisions for the personal ID information and so forth. But the bottom line is I have not seen anywhere that they have denied the information or rebutted the obligation imposed on them by statute and regulation.
Judge Niemeyer, so under those facts, at least as I understand your question, is if we just posit they've unreasonably delayed, there is sort of an implicit what is the remedy piece to your question, right?
Exactly. That's a legitimate point to argue. What is the remedy? But the question is first to find out what's at stake, and I think what's at stake is your general allegations and the allegations in the complaint and in your preliminary injunction and in your affidavits, is that they are not performing sufficiently adequately to carry out what they're supposed to do. But that's a lot different from them saying, we're not going to do it. What they're saying is we are trying to do it, and you're saying you're doing it pretty badly, and the courts have to step in because the delay is arbitrary and it's way beyond what is reasonable. If that's the point, then we have to ask the question is, what is our remedy? What's our role? Do we manage agencies' performance at any time?
Judge Niemeyer, yes. So the way I started the argument, I'm sorry if I didn't do a very good job with this, is we think we alleged box one. They didn't do anything at all. So we thought it was clearer that way. If the court
Well,
wants
that's
to look at the...
okay too. I mean, even if you allege they didn't do anything all, they haven't denied the responsibility. They haven't denied your specific request for any information. They claim that you can get it by an alternative method, and that's disputed. But my question to you is really, doesn't all of this go to a challenge to the agency's carrying out of its obligations? It's not denying those obligations. It's carrying them out inadequately according to your allegations.
Judge
And you
Niemeyer,
may be right on that.
Judge Niemeyer, on the facts as they came out in the preliminary injunction, that is where the case is heading. But that is, I want to be clear, that's cognizable under the APA as an unreasonable delay claim. And the remedy side, to the extent the court is like, okay, well, if that's true, what is the remedy for that? Is the court can enter an injunction that says you have to do it in a reasonable amount of time. If we prevail, we may lose on the merits of the track claim,
Well, you have
right?
to go back to the first question. The unreasonable delay is unreasonable delay in rendering a decision following a decision-making process. And the Supreme Court has pointed out that that is reviewable. But reviewing the ongoing performance, even though it is delaying, I mean, we get a lot of these cases involving Medicaid, which is, I think, 18 years delayed right now. It's horrendous. We've passed that on to Congress, and Congress has accepted the responsibility, and they're trying to do something there. But here, the delay is still pretty serious, as you allege it, and you may legitimately have criticism, but the question is, this is not a delay such as to deny a decision which is owed by them. This is a performance of an obligation to post these things and to put them in some kind of searchable order. And they're in the process of doing that. They're not denying it at all.
Judge Niemeyer, respectfully, the length of the delay is what we would say constitutes the denial. And I really do want to press on this factual point that I've had at the tip of my tongue for a minute, is in the 4.5 to 5 months after this case was filed, right? So January 2nd, no decisions are available. By the time briefing concluded in this court, they had 138,000 odd decisions available. It's been 5.5 to 6 months since then. They have only published 30,000. So the reason why this case is so critically important, and the reason why even an injunction as a remedy that says you must do it in a reasonable time is so critically important, is the agency has made clear it is not paying attention to this issue absent judicial, at least a case going on, right? I mean, like their actions in this case have made clear that they are not going to do it absent
Maybe
the court.
we should delay our decision, and then they'll get theirs done.
Yeah, if that worked, Your Honor. But my point is, this is why an unreasonable delay claim is cognizable. And I understand from this court's precedent, from Judge Wilkinson's questions and your own, that it's an uncomfortable place to be overseeing the agency's actions and how close do you get. Our position is it's just so premature. All we're asking is to go forward, get the record in the case. The government can make all of these merits arguments, and we'll just see what happens. And they may prevail or they may not. But the court had jurisdiction to hear it. That's our only point, Your Honors. And thank you for letting me go over my time.
Either of you all have any further questions of Mr. McGuire here?
No, I'm fine. Thank you.
I don't, thank you. I do not, thank you.
Let's hear from Ms. Wetzler.
Good morning, Your Honors. Lauren Wetzler, Assistant United States Attorney on behalf of the defendants. In April 2019, the Department of Defense discovered potential personally identifiable information, or PII, in decisions posted on its electronic reading room website, and began the labor-intensive process of reviewing, redacting, and reposting more than 200,000 board decisions from the past 24 years. The process of administering a sprawling website database is a complex, expansive agency operation. It is not a discrete, circumscribed decision. And as a result, it is not an agency action over which this court has jurisdiction under the Administrative Procedures Act, just as this court held in City of New York versus Department of Defense. Because this court need not reach the question of standing if it finds, just as the district court did, that it lacks jurisdiction under the APA, I'll start by focusing on the agency action question where this court just left off. The Supreme Court and this court have made clear that the hallmark of a justiciable APA claim is a challenge to a discrete and circumscribed agency action. and that broad programmatic attacks, like the one in this case, are impermissible. Decisions like issuing a permit or denying a benefit or publishing a rule or granting a patent or failing to make those decisions are cognizable agency actions. Administering a website, including reviewing, redacting, and republishing decisions and making those decisions searchable, is not a discrete or circumscribed agency action. And this court's decision in City of New York versus DOD is clear on this point and controls this case.
So I thought that as well that the SUWA decision of the Supreme Court was very much on point here, where the Supreme Court made a point of saying that general deficiencies in compliance lack the specificity for final agency action. The point is that it's to keep the final agency action from being completely eviscerated, because there's simply no end to, I'm no fan of the administrative state, but there's no end to deficiencies in agency compliance. And I don't like it. Judge Niemeyer referenced the Medicaid and Medicare and disability rulings and just all kinds of things. The agencies are behind schedule, and a lot of times it may be their fault, but in a lot of times it's not. The deficiencies in compliance may be because the agencies lack the appropriations, or they may have an insufficient staff, or they may be under unfunded mandates to do this and that. And it's a favorite strategy of the legislative branch to take the political credit for these lofty sounding mandates, and then to deny the agencies the resources to carry them out effectively. And if we recognize claims like this, we run the risk of holding agencies accountable for things that are not their fault. So I just think that's what the Supreme Court recognized in SUWA, is that this is a real can of worms we could get into. And all the cases are very, very solicitous of this final agency action, and having it represent something discrete. I mean, the courts have been good about safeguarding it because of the separation of powers concerns, and also the altogether legitimate concern is that our dockets would be overwhelmed if general programmatic attacks were allowed. So that's what we're up against here. One factual question I wanted to ask you: what kinds of you're under this dual mandate here? What kinds of personal information are you redacting? Mr. McGuire suggested that, this was a much more of a cut and dried kind of function, that all you really had to do is to redact the individual's name, and that's very mechanical, and it should be accomplished quickly and easily. I wasn't actually sure of that. I wondered whether it referenced whether the mandate from Congress about redacting personal identification information, does that extend to particular instances of malfeasance, sexual assault, or post-traumatic syndrome or those kind of things that could inflict members of our armed services. What is it exactly that you're redacting?
Yes, Your Honor. On that specific point, I believe Mr. McGuire was generally correct that what's at issue here when we refer to personally identifiable information is things like names, social security numbers, dates of birth, things that would identify individuals. There are other statutory provisions that call for redacting things like sexual assault history. So those are dealt with in some other statutory provisions, but the specific mandate in 10 U.S.C. 1552A5 having to do with personally identifiable information does refer to information that would identify a particular individual.
What if the text of a decision said that the commanding officer of platoon 16 on March 15th did this? Would that have to be removed?
Your Honor, I apologize. I don't know the answer to that question as to whether that would be considered something that is personally identifiable information.
I mean, it would be pointing to a particular person. It just wouldn't be.
Yes, I understand Your Honor's point there.
Okay.
So what I'm concerned about, I guess, is that a description of an incident, be an alleged sexual assault or some kind of post-traumatic syndrome, if you describe the incident in enough detail, it could be traced to the particular person or particular individual, even if that individual's name was not given or social security number was not provided. Is that a problem in the administration of this?
Your Honor, certainly the DoD takes very seriously the need to carry out this mandate and wants to be very careful in ensuring that veterans are treated with the utmost privacy. So it wants to be very cautious and very careful that the veterans are protected, and it wants to take very seriously as it goes through this process and make sure that it gets it right. With respect to Your Honor's prior comments about all of the reasons that this court and the Supreme Court in Norton versus SUWA has been careful to enforce the agency action requirement and to preclude challenges to the performance of programs, I agree wholeheartedly with Your Honor's comments, especially as they pertain to concerns about separation of powers. And that is, Your Honor's comments are exactly why the court should affirm here. This is going to Judge Diaz.
Ms. Wetzler, this is Judge Diaz.
Yes.
So is there any limit to an agency's sort of public stance of, yes, we're on it with respect to this database, for example, but yet doing little or nothing in practice? Is there any role for a court in that kind of a case? Your colleague on the other side seems to suggest that the DC Circuit, which handles these kinds of agency cases all the time, routinely steps in circumstances such as the one I've described, where there's just an extreme dereliction of duty on the part of the agency. So, and I'm not suggesting that that's the case here, but let's say 2 years from now, we're still looking at the same number of opinions in that database. Is there any role for a court in a circumstance like that?
Your Honor, a few points on that question. And I know Your Honor is referring to the Sierra Club decision that my opposing counsel has relied on extensively. That decision predates Norton versus SUWA. It also predates City of New York. More importantly, though, what the court said there was that when you have agency recalcitrance that amounts to an abdication of statutory responsibility, in that circumstance, you may end up in a situation where the agency's abdication is so significant that it amounts to a discrete enough action that it could be reviewable. We're not disputing that in the face of something so severe that an agency has completely abdicated its responsibility, that perhaps there could be circumstances that could come about. But that is so far removed from the situation we have here that it would be completely speculative for me to try to come up with that situation and draw that line in this case, and for the court to do so. DoD has been operating this electronic reading room website for 15 years before it had to take it down, and since 2019 has been engaged in step-by-step restoring the website. At the time that we filed our brief, there were 138,000 decisions, I believe, that had been restored. As of today, that number is up to 169,000. The agency would have loved to have been able to report an even higher number at the time of this argument. Unfortunately, COVID and other factors, personnel factors got in the way, but we are already up to 169,000 decisions that have been restored. There is still also the possibility of gaining access to additional decisions on an ad hoc basis by availing oneself of the process that has been available all along to request decisions that's available on the face of the website. And so this is anything but a case of abdication of statutory responsibility. This is a case of the agency doing its best.
Ms. Wetzler, so with respect to that sort of option to procure decisions on an individual basis, maybe the answer is you're not even obligated to do that. The agency isn't obligated to do that so long as they're moving steadily to replace the decisions. But your colleague on the other side, I think, would suggest that may work well for an individual who might be seeking, a particular decision, but in the line of work that they're in, where they're doing advocacy work for clients, that kind of ad hoc option just doesn't work very well. And it's the availability of the reading room with the search function that really makes the difference. So, that's more of a comment, I guess, than a question, but you can respond to that if you think, if you have a response.
Your Honor, I think that would take us into the question more of standing. So I can leave the question of agency action if the court has no other questions on that. I think I would ask the court the court can affirm on that ground solely. It need not reach the question of standing. And I think City of New York and SUWA compel an affirmance on that ground. But to the question of standing, the Dreyer case is, I think the parties agree, is the case that that would govern the standing inquiry. And the second question there is whether the denial of the information creates a real harm with an adverse effect. And what this court emphasized in that case is whether the plaintiff is suffering the type of harm that Congress intended to prevent by requiring the disclosure. And we would argue that whether NVLSP as an organization has access broadly to every decision it wants does not speak to the question of whether of the type of harm that that Congress was intending to prevent by requiring disclosure. That was a concern about whether service members themselves were able to defend themselves and to bring the types of cases they wanted before these boards, and that whether this organization is able to carry out its purpose, that the general purpose is not under Fourth Circuit law adequate to suffice to establish standing, and that is a proposition that this court made clear in the Southern Walk at Broadlands Homeowners Association case.
Ms. Wetzler, I mean, the whole reason for being for this organization is to advocate on behalf of veterans. And if that advocacy is made more difficult, more expensive, more cumbersome as a result of an inability to access the databases that the agency has historically relied on, I don't see how that doesn't amount to the sort of concrete injury that our cases and more recent Supreme Court cases seem to suggest is enough.
I think, the problem here, as we see it, is that the harm that Congress was intending to prevent here was the harm to service members, and specifically by obtaining information, and that the harm to this organization, as they have pled it, is not the harm that that was intended and that Dreyer would support.
So, for example, if they had to turn away, Ms. Wetzler, if they had to turn away clients simply because it's taking so long because of the inefficient way in which they have to do research on cases, that they just simply don't have the resources to take on additional clients as a result. They lose funding. Maybe their funding is tied to a quantitative number of clients that they can successfully process. I mean, these are all, we're obviously at the 12B6 stage, and standing may allow for expansion of the record somewhat, but if in fact all of that are consequences that flow as a result of the denial of this access, isn't that enough?
Your Honor, the problem here was that the plaintiff did not allege that those were the consequences here in their complaint. So they wanted us to treat standing as a facial matter, and the allegations that the plaintiff put forward did not specifically allege that those things were true. And so, you know, we've had some discussion in this argument about the question of going beyond. Certainly, for purposes of the APA jurisdictional argument, there's no question that the court may go beyond the record to consider the 12B1 argument there. Plaintiffs seem to want to consider the standing argument as a facial matter, and there the court looks to the under those circumstances, the court would look at the face of the complaint, where the plaintiff didn't identify any specific veterans or service members whose cases it wasn't able to evaluate or pursue. And so for that reason, we don't believe that the plaintiffs did adequately allege the kinds of things Your Honor just identified. If the court has no further questions, we would ask that the court affirm the decision of the district court, and specifically find that the plaintiff is seeking to improve the agency's operation of a website, but that is not the function of the APA, and as a result, there is no agency action over which this court has jurisdiction.
All right, thank you very much, Ms. Wetzler. We appreciate your argument, and Mr. McGuire, you've reserved some time for rebuttal, and we'd be happy to hear from you.
Thank you, Your Honors. A few quick points. We're having mostly, it seems like, a merits argument to me this morning about whether or not the agency has unreasonably delayed. And I guess my caution as we proceed into the rebuttal piece would be against that. And this is why I led my argument this morning with a focus on the complaint, that this case arises to the court on a very narrow set of allegations where the facts of the world have changed just because the case has now been around for more than a year. But several key factual points I want to highlight first. We're not talking about decisions issued yesterday by these boards. We're talking about decisions that in many instances could be nearly 20 or 30 years old, that have been around for a long time, and that the boards have had plenty of time to review or redact. And this court asked several questions of my colleague on the other side for her to give examples, essentially to provide a basis to say that there is a lot of agency discretion in what gets published. And she would not answer that question that way for the court. She was, I think, correctly pointing out that
your comments, the comments you just made really heighten my concern with what you're asking, because what you're saying, well, there are some of these decisions have been out for too long, or some of these decisions have been unreasonably delayed, others maybe not. I mean, what are we supposed to do? Go through these decisions one by one and say, this has been unreasonably delayed, this is not? In other words, I continue to feel like you're sucking us into a role of supervision, and it would be periodic supervision about the way this whole program is run. And we can't go through one individual complaint after another and say, well, in this case you didn't redact enough information. In this other case, you redacted. You took too long to redact. In other words, I just feel like that there's an undertow to this, and we're getting sucked into a more particularized view of the deficiencies of compliance, according to you, you would still have, you know, if we remanded this, you'd still have complaints, I think, about however this was carried out. The date for compliance would probably not suit you. The means that they're going to go about redaction might not suit you. What was redacted and what was not might not suit you. I mean, I can think of all kinds of subsidiary questions that would arise for the court, but we don't have a good vantage point for overseeing all this. We don't have the kind of expertise that in military service or in military records that the agency has. They have also an interest in making sure that their redactions are even-handed across a wide variety of decisions and everything. We don't have that at our disposal. So this is a question of agency expertise to some extent and agency familiarity, which brings about uniformity. And I just feel like I'm getting sucked in. Do you understand why this is troubling me? It's not your aims, which I think are laudatory. And, you know, if it were left up to me, I'd like to see these decisions available sooner rather than later. And your organization has a wonderful mission in assisting veterans with getting information in relation to their military records. It's a wonderful mission, but I just feel like I'm being swept into something and being pushed into something that's over my head. This is my problem.
Judge Wilkinson, I hear you loud and clear, and if I may try in a couple of parts to assuage some of those concerns as far as I'm able. The first is that we view Congress as having thrust the court into this because there is an unreasonable delay action under the APA. And anytime you have an argument about what is reasonable or not, it is always going to involve these sort of superintendent views of, is that okay, is that not okay, how long does it take? That's why the DC Circuit, which is routinely seen as the test for this, is effectively a rule of reason test. But I would really encourage the court to take a step back from worrying about that test at this stage. Because and if you look at our complaint, Judge Wilkinson, I think in fairness, we have really tried to avoid having this seen the way Your Honor has characterized it as a full-scale programmatic attack about everything the agency is or isn't doing with this. Because what NVLSP came forward and alleged is there is an explicit statutory, regulatory, directive command to publish these decisions on a centralized internet website. And the DOD's own regulation says, and I'll just quote it to you.
The problem is that the agency is caught between it's under a dual mandate. It's under, in one way, there's a tension between the mandates, because on the one hand, Congress is saying, do this, make this available. And then on the other hand, Congress is saying, yes, but only make it available under certain conditions where private information is redacted. So there has to be some consideration for the fact that this agency is caught in this tension and wants to satisfy both parties. And it doesn't. If it somehow made available very personal and private information that led to the identity of a particular individual and compromised that individual's prospects in life, there's another lawsuit there. So it has to. They're trying to navigate a very difficult course. That's all I'm saying.
Judge Wilkinson, I fully appreciate that, and so does my client, and that's why in every brief we have filed in this case, acknowledged that redaction is important. But if I can try again with another quote just from the agency itself about it's not the court trying to thrust them out there faster than they would otherwise be. And their regulation that they have never repealed, this is 32 CFR, I think it's 70.8L. They say, quote, they'll make the decisions, quote, shall be made available for public inspection and copying promptly after a notice of final decision is sent to the applicant. The agency itself has directed that it'll do it promptly. So the idea that they need an eternity for years, at this point, we're now years behind for more recent decisions, none of which have been posted that I'm aware of, is just not true in the agency's own view. But all we're saying to the court at this stage is we have alleged as discrete an agency action as possible, which is why below the department argued that this was an agency action because it was so non-substantive, that a publication requirement was so ministerial that it wasn't actionable under the APA. They jettisoned that before this court, but that was one of their initial arguments. And we're saying that the court shouldn't shut the courthouse doors on a jurisdictional argument to that type of ministerial discrete action. We should get to go to the merits where maybe we lose for all of the good reasons Your Honor is pointing out about superintending agencies. But those are merits arguments, and my client should be allowed to test the veracity of what the department is claiming.
The final agency action is a jurisdictional argument, and it's best, I think, for jurisdictional arguments to be resolved sooner rather than later, so that we're not plunging into a case over which we have no jurisdiction. And I just come back and say, when you read over the broad swath of cases dealing with final agency actions, the courts are very solicitous of this requirement. But at any rate, I think your time has expired. Do you have one final concluding statement you wish to make?
Judge Wilkinson, all that we would offer is that a lot of this is trying to address merits concerns that I fully appreciate, and we think that the court should limit the jurisdictional analysis to the text of the APA as we've suggested and address the merits later on. Thank you very much.
All right, well, we thank you very much. We appreciated both your argument and Ms. Wetzler's argument. And so we'll take a very brief recess, but I would hope we can move as quickly as possible into our final case. Thank you very much. And Sarah, if you can move us into our last case, I would appreciate it.
Mr. Piemonte?
I'm here.
Mr. Piemonte?
Piemonte, we're ready for you whenever you're ready.
My apologies. Can you hear me?
Yes, we can hear you.
Okay. My apologies, Your Honor. Good morning. May it please the court, I am George Piemonte on behalf of the appellant Antonio Bellota. The ALJ in this case committed 3 errors, the combination of which warrants a remand to the ALJ for a new hearing. Those errors are: 1, the ALJ failed to find Mr. Bellota is illiterate. 2, the ALJ failed to identify and resolve an apparent conflict between the vocational witness's testimony and the Dictionary of Occupational Titles. And 3, the ALJ failed to explain how she reached her conclusions as to Mr. Bellota's residual functional capacity. Mr. Bellota completed the 2nd grade, quitting to work on the family farm while sporadically attending the 3rd grade in his native land of Italy. Mr. Bellota's literacy, this is at record pages 516 to 520, in testing by the commissioner's own expert, established that his oral language, broad reading, broad written language, and written expression skills were at a kindergarten level or below, and the expert concluded that Mr. Bellota was illiterate. The ALJ in this case did not reject the opinion that he was illiterate, only that she only rejected that he had a severe mental impairment. That's at record page 16. The ALJ specifically stated that she did not include illiteracy in the RFC and oddly stated that it's not a medically determinable impairment. The commissioner defines illiteracy as the inability to read or write, a lack found generally in individuals such as Mr. Belota, who have little or no formal schooling. That's at 20 CFR 404-1564B1. The commissioner's own expert tested Mr. Belota, finding that he had a kindergarten or less reading level. The residual functional capacity is the most a person can do despite their limitations, as stated by the commissioner in 20 CFR 404-1545A1. The commissioner goes on to say that he will assess the claimant's residual functional capacity based on all relevant evidence in their case record. The ALJ decision that's before the court now is the third ALJ decision. Two prior decisions had been remanded by the appeals council. The previous ALJ in the two remanded decisions found that Mr. Belota is illiterate, and the ALJ in this decision does not dispute that he is illiterate. She just chose to exclude it from the residual functional capacity, even though the commissioner has said the RFC is the most a person can do. The most Mr. Belota can do includes not being able to read and write in English. The ALJ can't just pretend that that fact does not exist, but that appears to be what she's done. We are not asking the court, as the district court said, we're not asking the district court said we are asking the court to reweigh the evidence. We are not asking the court, the district court, nor this court to reweigh the evidence. We are asking the court to direct the ALJ to weigh the evidence of Mr. Belota's illiteracy in the first instance. The ALJ also failed to identify, get an explanation from the vocational witness, and resolve an apparent conflict between the vocational witness's testimony and the Dictionary of Occupational Titles. According to the DOT, the three jobs identified by the vocational witness and accepted by the ALJ to deny Mr. Belota's claim, those being cleaner to dining room attendant and counter supply worker, all have DOT language level of 1. Language level 1 requires the ability to, and this is per the DOT, recognize meaning of 2,500 2 or 3 syllable words, read at a rate of 95 to 120 words per minute, compare similarities and differences between words and between series of numbers. Mr. Belota is illiterate with a reading ability of a kindergarten level or less, according to the commissioner's own expert. This court held in common.
What about the education he received in Italy? I thought he received some rudimentary education there, and then he's been in this country for a good bit of time, and worked in a fine job as a tile layer and a tile setter. Wouldn't he have, with this history of work as a skilled laborer, wouldn't he have acquired some proficiency in English during all this time? I'm just wondering, in light of his work history and in light of the length of the time that he and his father have been in the country, wouldn't he have acquired some basic proficiency in English?
Your Honor, we don't dispute he can speak English, although with a very broken and with a heavy Italian accent. That's not the issue. The issue is if he can read and write English. When he came to the United States, and I believe, if I recall correctly, was 1979, he was approximately 19, 20 years old at the time. He began working for a person named Bruno, and Bruno spoke Italian to him. and taught him how to lay tile. He did not know how to lay tile when he came to the United States. He had worked on the family farm.
Well, I don't understand here, because if you're going to be a cleaner, housekeeper, or a laundry laborer, and these were some of the things that the vocational expert identified as jobs, a counter supply worker, a dining room attendant. I don't understand why those jobs would necessarily require an ability to read and write English as much as they would require an ability to just speak the language. How does a dining room attendant, for example, need to, or a laundry laborer necessarily need to read and write English as long as they can speak the language? Because I think that was what was on the mind of the vocational expert.
Well, Your Honor, you're getting directly to the crux of the problem. We don't know, because the ALJ didn't ask, as she was required to under Social Security ruling 004P and this court's holdings under Pearson and Thomas. As this court held in Thomas, and it cited Pearson, the ALJ has an affirmative duty to make an independent identification of apparent conflicts, which means that the ALJ must recognize and resolve ways in which the vocational witness's testimony seems to, but not necessarily, conflict with the expressive language of the DOT, even if that conflict is not obvious. And according to the DOT, these jobs require the ability.
Excuse me, sir.
Yes.
Judge Diaz got disconnected. I'm going to reconnect him right now. So please stand by for one moment.
Okay.
Are you connected now, Judge Diaz?
No, sir. I've got to connect him back. It's going to take a minute.
Sarah, where are we now? Has everyone connected?
Judge Diaz, are you back, sir?
We're checking
Yes,
on that
sir.
right now, Your Honor. He is connected.
Okay, Judge Diaz is back.
Judge Diaz, I'm not sure at what point we lost you, but where I was in the discussion was Judge Wilkinson had asked a question about, do these jobs, do you have to be able to read and write to do them, that the vocational witness identified? And that, as I pointed out, that gets to the crux of the error by the ALJ, because we don't know beyond what the DOT says. The DOT says that the worker has to have the ability to read and recognize 2,500 2- and 3-syllable words and differentiate between the meanings of words. This court addressed a similar situation in Pearson when discussing that the DOT does not differentiate between various directions in reaching. This court said, although we could guess what these occupations require in reality, it is the purview of the ALJ to elicit an explanation from the expert as to
Mr.
whether
Piemonte, can I ask about that? So why do we have to gauge what the classifications require in reality? I mean, why can't we just accept the DOT's assertions at face value?
Well, Your Honor, because we have evidence that Mr. Belota is illiterate. And there's
well, maybe you misunderstood my question. What I'm suggesting is that the DOT has indicated that there are certain requirements of literacy that are associated with these jobs. So why isn't that sort of conclusive? Why, unless, you know, the other side argues that those are maximum requirements, and perhaps they're not required for each and every case and each and every job. Do you concede that point, that, as Judge Wilkinson pointed out, that a vocational expert, or the ALJ in this case, could conclude that a particular job might not necessarily need the kinds of writing and reading skills that the broader DOT classification seems to suggest?
No, Your Honor, I don't concede that because we don't know. The ALJ is not a vocational expert. The ALJ is directed by the commissioner's rulings and by this court that there appears to be a conflict. She was required to inquire from that vocational witness whether or not that 2,500 reading and writing ability is in fact necessary in those three jobs. The vocational witness very well may have said, no readings required at all. But we don't know that because she failed to ask the question. And that is the error. And that is directly contrary to what the 004P directs her to do, and directly contrary to what the Fourth Circuit directed her to do in Pearson.
All right, thank you, Mr. Piemonte. Judge Diaz, if you had the chance to ask the questions that you want, I don't know how much you were not connected with us. If you had the chance to ask the questions you wanted.
I have, thank you.
Well, Judge Niemeyer, do you have any questions of Mr. Piemonte?
No, I'm fine, thank you.
Okay. Mr. Mervis, let's hear your side of it, okay?
Yes, Your Honor, thank you. David Mervis on behalf of the Commissioner of Social Security. May it please the court. I'd submit that this case, because it involves the intersection of a number of different regulations, rulings from the Commissioner, it ends up being seeming a little bit more complicated than it is. My plan today, if I could, is to make 4 points to explain to this court, as we've done in our brief, why the district court was right to affirm. So the first point here is that, and this is where we started our brief, is that the ALJ's finding that Mr. Belota could perform work at the medium exertional level renders the dispute about this educational level, it renders it moot, excuse me. And the reason for that is under the Commissioner's regulations, regardless of Mr. Belota's education level, if he can perform the work at the medium exertional level, which is what the ALJ found here, he's not disabled under the regulations. And we've set out in our brief, just to recap what the evidence shows. And in this case,
Mr. Mervis, can I ask about that? So Mr. Piemonte points out that with respect to this issue, that sort of the key paragraph relating to this medium work capacity misstates the record evidence as to the nature of the x-rays and when they were taken, that the ALJ seemed to rely on to show that there was some degenerative changes in his knees. And that happens more than once in this case. So it troubles me that we're relying, that the government is relying on a conclusion that seems to be untethered to the actual facts in the record.
Yes, Your Honor, we fully agree that there is a error in the ALJ's decision as to the date of these x-rays. Now, what we're talking about is page 543 of the administrative record. I'll note that it appears that the document was printed in February of 2012. The ALJ identifies in that paragraph on page 19, he identifies the X-rays as occurring in February 2012, and that appears to be the date that that the document was printed on 543 of the record. Regardless, what we've argued and what I think is essential here is that the ALJ specifically notes that Mr. Belota's treatment began, or he had treatment during the relevant period here in February 2010, and that's what this note is a treatment note from February 2010, and that he doesn't have treatment again until March 2012. So that's just right below the paragraph that Your Honor and that Mr. Piemonte is
right.
But
the treatment, the statement with respect to there being no treatment records prior to the date last insured follows on the heels of this misstatement of the X-ray, which seems to suggest that or at least I don't know, seems to at least reasonably suggest that the ALJ discounted the X-ray, and which I assume is a treatment record, right? And if he or she, I don't know if this was a male or female ALJ, discounted that record, which seems to me to be significant, doesn't that call into question the actual conclusion as to the type of work that this claimant was able to do?
It doesn't, Your Honor, and the reason why is because the ALJ, the ALJ, it's a she. She indicates that there's no records from the treatment from the period here, this 10-month period in 2010, that show significant limitations due to the knee impairment.
Well, isn't the X-ray record a treatment record?
It is absolutely a treatment record. So the key
okay,
there
so,
is that
doesn't the X-ray record show impairment?
Our position, Your Honor, is that it doesn't show significant impairment beyond what the ALJ has found. So the treatment record indicates, and the X-rays indicate, that Mr. Belota has knee arthritis in the right knee. He has got off and on knee pain. This is not an indication that he is precluded from performing all work. It's not an indication that he's precluded from performing the medium work that the ALJ found was warranted, was appropriate. And again, the other piece here is we've got opinion evidence from two state agency consultants who looked at the entire record as well and came to the same conclusion. So the ALJ isn't out on her own on this point. She has the benefit of two state agency consultants, Dr. Linster and Dr. Drummond, administrative record 135 to 36 and 150 to 51, who both came to the same conclusion, that Mr. Belota had the ability to perform medium work. Again, what the ALJ's, the typo in that paragraph that Your Honor refers to on page 19 is regrettable, but it doesn't change the outcome. The ALJ.
So let me ask, just to follow up on that, and I apologize for interrupting you, but in isolation, I suppose that might be a reasonable conclusion, but there's also the history about this case. This is the third ALJ that has reviewed this record. Two prior ALJs apparently came to the conclusion that he could only do light work and that he's illiterate. And so now we've got this third ALJ indicating no, and I recognize that those two prior opinions aren't binding on the current ALJ, but she's now saying, never mind, he can do medium work, but she's relying on the face of it, excluding a significant part of the treatment record that might suggest otherwise. So that's my concern about this case, is that it's got a long and tortured history with other decision makers suggesting findings in favor of the claimant, and now we've got this finding in the record adverse to the claimant, which is littered with mistakes, your view of it, typographical errors, Mr. Piemonte's view of it, refusal, not a refusal, but not taking into consideration the entire record, the entire medical record that's available with respect to both his physical condition and his ability to read and write English. So that's my concern.
We certainly understand Your Honor's point. Your concern that this case does have a long history, but again, as you know, as Your Honor's aware, those and as Your Honor indicated, those prior decisions were vacated. due to other errors, and the ALJ, she's got a responsibility to review the record as it stands before her, without regard to those prior erroneous decisions from other.
Is this individual in his 50s, or what are we talking about here?
That's right, Your Honor. We've got a period of time between his 50. I guess he turned 53 during the relevant period here. So it goes. I
have some of the same questions that Judge Diaz has. It seems to me that it's undisputed that he has a serious problem with the osteoarthritis in his right knee, and that is degenerative. If you have osteoarthritis, it generally gets worse over time, and even on the present view of the record, there are substantial limitations on his ability to kneel and to climb. So he's lost an ability there. His joints are not in any way flexible or limber, and when you add obesity to it, he's likely to that's got to put a lot of pressure on his knees, because they're going to be carrying a lot of weight. And then in addition, we have this history that Judge Diaz points out, and we can dispute the amount of education, but this is a gentleman who's barely literate, when you combine his limited facility with English, with his obesity and arthritis, and the limitations that everyone has found on sort of rudimentary motions, it just seems to me, to say this man is not disabled seems to me, I'm just not sure it adds up. I think between the obesity and the arthritis and the limitations on kneeling and his very limited education, that this gentleman is in a bad way when you look at it all.
We certainly appreciate that, Your Honor. One thing I would make a point of is that this is what we call a closed period, and so we've got a period where Mr. Bellotta had to demonstrate disability before December 31st, 2010. So Your Honor referred to the degenerative nature of osteoarthritis, and we certainly don't dispute that. But we've got a 10-month period from February of 2010 to the end of the year. And so that's the period that the ALJ is considering. And so whether his condition worsened after that, and in fact, there may be evidence of that. His right knee, I guess, was the impairment during the 10-month period in 2010, but there is indication that his left knee got worse, and maybe his shoulder got worse. But again, those other impairments simply don't play a role here.
Well, I know that, but on the other hand, you have to think to yourself, I mean, these things, these hearings and everything go on interminably, and you can almost take judicial notice of the deterioration in someone's joints because of age and wear. And so this person has been up and down the ladder, remand after remand after remand, and I wonder if there isn't doesn't there come a time when some resolution is necessary, and not drag him through another set of proceedings? This is just a general concern of mine about this case.
certainly understand that, Your Honor, and our position would be that you know, as you know, as unfortunate as it is that it took multiple decisions to get a decision that is defensible, that's what we've got here. So there is no need for another hearing, another decision, because this decision is defensible. It's the findings that the ALJ made are supported. And I, again, you know, what we're talking about here is an individual whose burden it is to prove disability. So he had the burden of proving disability during this 10-month period. And this note that we're talking about at 543, it's the only record in the administrative record from this period of time. So it indicates that he's got arthritis, and it indicates that he should take a non-steroid anti-inflammatory. And that's it. So what the ALJ...
Can I ask you a question? It looks as if the vocational expert testified that he could do medium jobs and listed a few, and could do some light jobs and listed a few. And the ALJ parroted that in her opinion, basically listing the jobs that he could do, medium jobs and light jobs. And then the next paragraph, the ALJ says, these findings are consistent with the Dictionary of Occupational Titles. But the petitioner here points out that the occupational titles requires a level of education, reading up to, 250 words and that type of thing, that have not been demonstrated here. What's your response to that? The ALJ said the vocational expert's testimony is consistent with the DOT, but yet the vocational expert assumed that he couldn't read and write English and pointed out these jobs, yet the dictionary provides that he has to have this level of speaking in order to do these jobs. I mean, reading, level of reading.
Sure. Two things on that, Your Honor. The first is that the ALJ's finding, and that's just the page before that on page 20, is that an individual with a marginal education who's able to communicate in English, and there's no dispute about his ability to speak and communicate. So an individual with a marginal education is able to perform this work. And that's my question. That's my question.
The dictionary uses marginal education, but then when you look to a marginal education, it defines it above the level that's demonstrated for the petitioner here. It defines a marginal education as someone who can read up to 250 words, 90 words per minute, has a vocabulary of 2 and 3 syllable words, a fairly large number, 2,500 words or whatever, and that has not been demonstrated. That goes to the crux of my question. It has not been shown that he is marginally educated.
Well, I think Your Honor is asking, if I understand your question, Your Honor, there's really two pieces here, because the language development level in the dictionary is indeed what you cited, the 2,500 words, and that's a language level. That's not the marginal education that the ALJ found. The marginal education...
Marginal education is a term of art, and it's defined by regulation, right?
That's right, Your Honor.
And what's the definition of a marginal education?
Right. Absolutely, Your Honor. So it's 404-1564-B2. Marginal education is the ability to perform unskilled work. So it means the ability in reasoning, arithmetic, and language, which is needed to do simple, unskilled types of jobs. That's what the ALJ found. So there's not a finding as to the number of words, the number of reading, the number of words that an individual can read. That's in the dictionary. The regulatory definition, and this is crucial here because the regulatory definition is controlling. So what the ALJ is finding is that this individual is able to has the ability in reasoning, arithmetic, and language to perform unskilled work. That's it. That's above illiterate, to be sure, but that's the finding. And there's absolutely no conflict between that finding and what the dictionary says about language level or anything else. Because
Mr. Mervis, if we were to find that finding with respect to literacy was just simply not supported by the record, then how does that impact the analysis that follows?
Well, Your Honor, as I indicated at the top, Mr. Belota under the regulations is not disabled if he can perform medium work and he's illiterate, and he's not disabled if he can perform light work and he has a marginal education. So the ALJ's finding is there are several different ways, I suppose, would be my answer, that the ALJ's finding is supportable, that remand isn't required. Coming at it the other way, this court would be would have the responsibility or would have to find both the physical finding and the educational finding to be unsupported, because if either one is supported, the ALJ's decision here, well, I guess what I should say is it doesn't make a difference. If either one is supported, then the other one is moot.
But you're relying on that conclusion assumes that there are sufficient numbers of jobs in the national economy for someone who is illiterate for medium work. And is it clear from this record that the vocational expert made that distinction, or were they just assuming that because the ALJ had found that he had a marginal education, that was all that they were looking at in terms of the number of jobs available in the national economy?
Sure, and with respect to what the ALJ asked and what the vocational expert responded, there really are two pieces. And so what the ALJ asks is initially an individual with a margin with this level of education, and those jobs are identified, the first three jobs that the individual, or that the vocational expert can perform. And then the ALJ asks this additional question, and this is on 62 of the record. So an additional question about whether these jobs can still be performed without a requirement to read or write in English. And the vocational expert adjusts her testimony slightly, swaps out one of the jobs for another. So what we're left with is this another set of three jobs: cleaner, dining room attendant, laundry laborer. And the vocational expert is specifically considering this question of ability in English. So what the vocational expert gives the ALJ is this understanding that there are different jobs that are available for an individual.
Let me ask you, are those jobs require 2,500 words of vocabulary?
Well, Your Honor, what we can do is we can look at the dictionary's description of the job.
Well, I'm asking you that. Do the dictionary descriptions of these jobs include a vocabulary of 2,500 words?
They certainly don't appear to me to do that, Your Honor. Cleaner, it discusses in.
No, I'm saying that in the dictionary.
Well, the response, I guess, what I'm trying to do, Your Honor, forgive me. What I'm trying to do is yes, is answer your question this way. The dictionary includes a language level of 1 for each of those jobs. That is undisputed. What I point out is that the dictionary
Okay, just let me take my question further. Let me just take, because my question is, okay, the dictionary includes a level of 1, which requires 2,500 word vocabulary, right?
That's right.
And so the vocational expert relied on that definition and did not explain why this man who doesn't have a 2,500 word vocabulary can do those jobs. My biggest problem is the vocational expert assumed that the dictionary was being complied with and even testified it was consistent. Her findings were consistent with the dictionary. But the dictionary says you need 2,500 words. You need to be able to read at 90 words per minute, and the record doesn't support that.
What I'd say to that, Your Honor, is this. We know, because the regulations explain, that illiteracy is not per se disabling. So
I understand that. I want you to answer my specific question. My specific question is, she related two jobs defined in the dictionary, which requires the person to have 2,500 word vocabulary. The vocational expert testified that this man can do those jobs. And she said her testimony was consistent with the dictionary.
She did, Your Honor, and I take Your Honor's point. The vocational expert's position here is that these jobs can be performed without the requirement to read or write in English. That's the testimony. And so the question then is whether the ALJ had a reasonable basis to rely on that testimony, whether they're, because it is certainly true that every hearing might benefit from an additional question. But
Mr. Mervis,
you're not being fair with the record. I'm reading now at 61 in the record, and she goes through the jobs for both medium and light, and she gives the actual dictionary number for each one of those. Now, the dictionary number for each one of those requires a level 1 education. And she says, that her conclusions are consistent with the dictionary, but yet her conclusions assume he can't read and write, where the dictionary says you have to read and write at a certain level.
Your Honor, no. What I would dispute that just in the following way. The question that the vocational expert was asked is then about whether you can do these jobs without the ability to read or write in English. And so then she goes on to say, well, the dictionary doesn't specify English language, but that's what I'm assuming. So the vocational expert is asked about English proficiency, not literacy per se, not ability to read 95 words per minute. And so I don't think the vocational expert's contradicting herself here. I think the vocational expert is saying that these jobs, my expertise tells me these jobs don't require the ability to read or write in English.
All right. Well, thank you, Mr. Mervis. Judge Niemeyer, do you have any further questions of Mr. Mervis?
I don't.
Diaz, do you have any further questions?
No, thank you.
Mr. Piemonte, you have some time for rebuttal. We'll be happy to hear from you.
Thank you, Your Honor, and I will get through this as quickly as I can. First, Mr. Mervis said it took them 3 times to finally get an ALJ decision that was defensible. This decision is not defensible. As Judge Diaz pointed out, it is riddled with errors and misstatements. I'm going to first address the vocational testimony. The issue is not on whether or not the vocational witness said something wrong. The issue is that the ALJ failed on her direct duty as directed under Social Security Ruling 004P and the Fourth Circuit precedent in Pearson to identify and obtain an explanation for an apparent conflict. And there is an apparent conflict. As Judge Niemeyer pointed out, the dictionary requires the ability to read 2,500 2- and 3-syllable words and read at a rate at 95 to 120 words per minute. There's an apparent conflict. The ALJ failed to inquire from the vocational witness and get an explanation for that requirement. The ALJ also failed in suddenly finding that Mr. Bellotta.
Can I ask you about that? If this is a hypothetical, but if the vocational expert said, I understood what the dictionary said about 2,500 words, but I also know from my own experience, these jobs do not require that kind of reading and writing ability. And so we send it back and we say, okay, there's a discrepancy between what the dictionary says and what the ALJ found. Give us an explanation. Would we be sending it back just for the ALJ to say, yeah, there is a discrepancy, but these jobs do not require, in fact, reading and writing? because the lowest level that the dictionary uses is level 1. They don't have an illiteracy level. And so the ALJ puts in 2 sentences and says, okay, we recognize he can't read and write, but he can still do these jobs of a laundry helper and the counter, making sandwiches and that type of thing. Is that possible?
No, sir, because the ALJ is not qualified to make that determination. She is not a vocational expert. She is required to obtain vocational testimony or other vocational evidence. We don't know what that is. We don't know what those jobs require.
The vocational expert was asked basically that he couldn't read or write English, right? And gave her opinion based on that assumption, didn't she?
There was some dancing around whether or not he could read, but there was no direct inquiry by the ALJ to the vocational witness. Is he capable of doing these 3 jobs that you have identified because he is illiterate? She never made that inquiry, which is what she's required to do, because there is a conflict between what the DOT says is required and what his actual ability is. And we can't make an assumption on evidence or speculate on evidence that's not in the record. There is no evidence in the record of what amount of reading and writing these jobs actually require. Excuse me. Your Honor, I hope I fully responded to your question. As to the RFC, the ALJ incorrectly, this is at record page 19, incorrectly said Mr. Belota had a normal range of motion of his right knee. Well, the examination by the commissioner's expert in 2009, which is before the period of under consideration, indicated that he had a significantly decreased range of flexion in his right knee, as well as some reduction in his left knee. The commissioner has said in Social Security ruling 8310, when discussing medium level work, the commissioner specifically said, flexibility of the knees as well as the torso is important for this activity. So for the ALJ has never explained how she got to medium. Mr. Mervis had to take exception with one of the statements that he made during his argument. He said that the ALJ, that she relied on the non-examining state agency opinions. No, she didn't. We don't know because she didn't say. The ALJ never explains how she concluded that Mr. Belota is capable of doing medium work when the prior ALJ had twice said he could only do light. The ALJ has misstated and or cherry-picked evidence in order to find Mr. Belota not disabled. In Monroe, this court said the ALJ must form a clear and logical bridge from the evidence to her conclusions. And then this court in Thomas, citing its decision in Woods, said a proper RFC analysis has 3 components: 1, evidence; 2, logical explanation; and 3, conclusion. The second component, the ALJ's logical explanation, is just as important as the other 2. Indeed, our precedent makes clear that the meaningful review is frustrated when the ALJ goes straight from listing evidence to stating a conclusion. And that's exactly what the ALJ did here. And she didn't even state the evidence correctly, as the commissioner has admitted. And then just very quickly, lastly, the ALJ never even acknowledged Mr. Belota's obesity that Judge Wilkinson was talking about, let alone do the individualized assessment of the effects of obesity that is called for in SSR 021P, which would directly affect pain and limitations on a weight-bearing joint, such as his right knee.
All right, thank you, Mr. Piemonte. We appreciate it. And thank you, Mr. Mervis. We can't come down and shake your hands, but we appreciate your argument nonetheless. And I'm going to ask our good courtroom deputy to adjourn court and then reassemble us within 5 minutes for a conference.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.